start a chapter by saying it's too long. That's not very motivational.
Well, there we go. It's another long chapter. It's got a lot of stuff in it. Okay. But we've gone over some of the things in here, so it's not going to be too bad. But it does have a lot of information. It's just too long for us to be able to finish today with the amount of time we got left. All right. So this chapter covers leases, landlords and tenants, and the types of leasehold estates and lease contracts and landlord-tenant issues and inspections and all kinds of other good stuff like that. Some things we may have already discussed, though, in this class. So in this chapter, you're going to be able to explain the characteristics of the 4 types of leasehold estates, describe standard provisions of a lease, including various forms of eviction. We're going to learn about different types of eviction, the Truth in Lending and Americans with Disabilities Act. We're going to learn about the differences between various types of leases, as well as being able to identify the functions of a property manager, what the primary function of a property manager is anyway. So, Chapter 12, leases, landlords, and tenants. So what is a lease? Well, a lease is an intangible asset that is personal property. It's where an owner intentionally conveys their property to a tenant who is going to occupy it for a limited amount of time as defined in the lease. So a lease is both a conveyance as well as a contract in that regard. So the owner is the lessor who intentionally transfers most of their rights. You know, they're not transferring their rights to sell the property, right? To the tenant who will have the right of possession of it for a limited time as defined in the lease. Demise is a transfer of property by lease, and every lease has a demising clause in it describing what the landlord is renting and that the tenant is taking possession. So the lease is both a contract as well as a conveyance. So let's highlight the first sentence, the first 2 lines on page 195, as well as the last sentence in that same paragraph that describes those things that I just read on this slide. First sentence and last sentence on that paragraph highlight. And then we'll turn the page. Turn the page. And just like we went over in the last chapter, the statute of frauds, what does it state? That all sales contracts must be in writing. Leases have to be in writing if they're 3 or more years. Leases can be recorded if they're 2 or more. Leases must be in writing if 3+ years. Unless a real estate licensee is involved, right? Because we always have to get it in writing. And let me see how exactly I had it written on the chapter 11. We went over that statute of frauds in chapter 11. Here we go. I knew I had something a little extra written there. Okay, so yep. Okay, so I'm gonna add this in there. Just made that little mod. So it's extremely to rely on any verbal contracts. We should always get things in writing. This is only pertaining to when it's the owner of the property and they're not using a real estate agent. Mhm. And there you go. La, da, 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 da. Okay, now I got that matching slides up from the other chapter. There we go. All right, so statute of frauds requires that all contracts be in writing if they're for sale, but if they're for lease, if a real estate licensee is not involved, it always needs to be in writing. But if they're not using an agent, as long as it's 3 or less years, they don't have to have it in writing, but it's extremely risky doing that. Leases can be recorded in a public record if they're 2 or more years. And once again, statute of frauds administrative code says that if we're entitled to a commission, we always got to get it in writing. Estates and land. Okay, so let's highlight on page 196 in the second paragraph, first sentence, about the statute of frauds there, 3 years, 2 years. So that's in that first sentence. And we're going to go over the 4 types of leasehold estates. Now, in an earlier chapter, we went over the estates and land, the types of estates that were ownership in chapter 6 or 7, I believe it was. Chapter 6, apparently. What is an estate and land? It describes the amount and kind of interest that someone has in real property. And there's 2 categories of estates. We have freehold, which are the ownership category, and less than freehold, which are leasehold estates. This chapter, we're going to be going over the leasehold estates. Leases are not ownership. You do not own real estate when you have a lease. It's an owner intentionally transferring some of their rights to the tenant for a limited period of time as they defined in the lease. So leases are considered personal property that are an intangible or incorporeal asset. So here are the 4 types of leasehold estates. Let's highlight leasehold estates and write the number 4 in front of it. And then highlight each one of those in that numbered list. Estate for years, periodic estates, estate at will, and estate at sufferance. Estate or tenancy at will, estate or tenancy at sufferance. Now, with any of these estates, rent is always due at specific intervals per the lease. If it's not stated in the lease, New Jersey law states that the rent is due in the arrears. That means at the end of a period for which something is due. Where's your rear? Behind, in the end, right? So that's what arrears means. It's at the end of a period for which something is due. Anyone who terminates a lease early is considered to be in breach of contract. And a holdover tenant is a tenant who did not vacate the premises after their lease term rights had expired. Now, is that necessarily a bad thing? No. A landlord could accept a holdover tenant, or they could evict them. Like if that holdover tenant isn't paying rent, or are they paying rent? You know, it's up to the landlord if they are paying rent, whether they're going to keep them or not. Eviction is the legal process of removing a tenant through the court system. A landlord cannot lock a tenant out or turn off their services or physically remove them. The tenant does have rights. Eviction is the process of revoking those rights. Oh, actually, that sounds pretty good. I want that written in there, right? Eviction is the process of revoking those rights. All right. What are the characteristics of a leasehold estate? Once again, we have estate for years, periodic estate, estate or tenancy at will, and estate or tenancy at sufferance. So, an estate for years need not be for years. It's for a definite period of time with a fixed date, for a fixed term with an end date in it. So we see figure 12.1 here in the book. I have a picture of that. No, I don't. I should add a picture of that. So we have it's for a fixed time. So I want you to write that at the end of that, where it says estate for years, distinguishing characteristics for a fixed period of time. I want you to write for a fixed period with an end date in it, right at the end of that. For a fixed period with an end date in it. Fixed period with an end date in it. Fixed period with an end date in it. All right. Then next to estate from period to period, I want you to write has a new renewal date in it. Has a renewal date in it. Has a renewal date. Has a renewal date in it. And then next to estate at will, just highlight for an indefinite period of time. And then nothing really there to write next to estate at sufferance. Okay. All right, so let's start off with estate for years down here. Do not let the name fool you. Estate for years does not mean that it has to be for a period of time that is a length of years. Estate for years need not be for years. Its key characteristic is that it's for a fixed period. Has a start date in a lease, has an end date. It's for a fixed term. You know when the lease is going to end. It could be for 1 week, it could be for 3 months, it could be for a year, it could be for 2 years. An estate for years, its key characteristic is that it's for a fixed term with an end date. Fixed term with an end date. Fixed term with an end date. Would be a estate for years. Now, it's for a specific defined period of time with an end date. No notice to quit is required to terminate at the end of the lease term. When the lease has expired, if the tenant did not renew the lease, they know when they gotta get out on when the end date of the lease comes up. So because it has an expiration date in the lease, if the tenant does not renew, they must vacate at the end of that term. So let's highlight the title, estate for years, and then the first sentence. skip the second sentence and highlight the third that says no notice is required to terminate such a lease at the end of the term. Then the second paragraph there, we're going to highlight the first sentence. An estate for years need not necessarily last for years or even for 1 year. And then in the last sentence, highlight its distinguishing characteristic is that it begins and ends at a specific time. Okay. Everybody get all that?
Yeah.
All right, cool. So I'll make sure I'm not going too fast. All right. Now, a periodic estate is also known as an estate from period to period. It is a lease that does have a date in it, but that date is a renewal date. So it's a lease with a date in it. That's a renewal date. The lease will automatically renew for the same amount of time the original lease was written for. 1 month will automatically renew for another month, 3 months for 3 months, 6 months for 6 months, 1 year for another year, 2 years for another 2 years, 3 years for another 3 years, and so on. So a periodic estate works like that. It'll automatically renew unless the tenant gives notice to quit. That lease will automatically renew. Either party may give notice to quit, to terminate. How much notice to terminate would depend on the term of the lease. Either party may give notice to quit or to terminate before the lease renews. Before the lease renews. How much notice to terminate depends on the term of the lease. So if it's week to week, 1 week's notice is required. Month to month, 1 month's notice. If it's a period of years, 3 months notice is required. Now, check this little bit out. Let me see. I'm not sure if you guys can see this because the text kind of, I got to resize it to fit. There we go. So when a tenant gives notice to quit, but then they do not vacate, they could be held liable for double the rent for every month they remained that they held over for. Okay, so when a tenant gives notice to quit, then does not vacate, they can be held liable for double the rent for each month that they've held over. So let's go highlight the periodic estate, sometimes called an estate from period to period, are created when the landlord and the tenant enter into an agreement that continues for an, cross out the word indefinite. I don't want this confusing you. Just cross out the word indefinite. When it continues for a length of time without a specific expiration dates. They didn't have to use the word indefinite there to explain that. And then go to the last paragraph, last sentence in that paragraph, and highlight the agreement is automatically renewed for similar succeeding periods until one of the parties gives notice to terminate. Then on the next page, 197, just highlight the term holdover tenancy. And the following sentence, a New Jersey tenant who remains in possession of a leased premises after giving their notice of intention to quit the premises may be held liable for double the rent. All right, tenancy at will, estate or tenancy at will. This one is for an indefinite period of time. This is why I want you to cross it out, because I didn't want you to associate that word with periodic estate, because it'll matter come exam time. An estate or tenancy at will, at the landlord's will. It's an estate for an indefinite period of time. What does that mean? There's no length of time specified in the lease for the term. The tenant can stay as long as they like, as long as the landlord allows it. Either party must give 3 months notice to terminate. It's terminated automatically by the death of either party. And both parties must agree to the indefinite term with 3 months notice to quit. An example of where this would be used would be if the state notifies the property owner that they're going to take away the property by eminent domain. Well, the owner does not know when exactly that's going to occur. So in the meantime, they got to still pay their bills and such. They could rent out their property, but they can't sign a 1-year lease with a tenant, because if a property is getting taken by eminent domain, the owner is responsible for getting that property vacant. So the landlord could rent to a new tenant and say, this is going to be a tenancy at will. When the state notifies me that they're going to officially take the property at a certain date now, they're going to give me enough notice. So I will give you at least 3 months notice that you got to go. If we're cool with that, then you can stay here as long as you like until they notify me. That's what a tenancy or estate at will is. So let's highlight the first sentence under tenancy at will. And then in the second paragraph, the next to last sentence we're going to highlight. The term of an estate at will is indefinite, but the estate may be terminated by giving 3 months notice. And then lastly, an estate or tenancy at sufferance is basically when a tenant lawfully came into possession of those premises because they had a valid lease at some point in time. This is not squatters. This is when a tenant had a valid lease, their lease expired, and the tenant did not renew that lease, and they did not move out. They're now a holdover tenant. This is not squatters' rights, which would be an easement by prescription that they were trying to get. A holdover tenant is not paying rent and can be evicted at any time for non-payment of that rent. So no notice is needed by the landlord before they start the eviction process. So just as fee simple absolute is the highest estate in land, tenancy at sufferance is the lowest. You got a tenant whose rights expired, they're not paying rent, they didn't move out, but they do have rights. The landlord can't just drag them out by their hair. They can't shut off the services, especially if they were included in the rent. They can't change the locks, they can't shut off the water or the heat, you know. The tenant does have rights in that regard. So a tenant at sufferance is basically this. The tenant who had a valid lease, their lease expired, they did not renew the lease, they did not move out, and they're not paying rent. So every day that they remain there, they're causing the landlord to suffer. Thus, the tenancy at sufferance. but that tenant still has rights. The landlord cannot evict, cannot kick them out. They need to do that through the court system. Remember, the only way to remove a tenant is through the court system. You can't go in there and get your bouncer friend Jojo to go bust some heads and get the round up the boys. We got to get rid of these people. Can't do that. Tenants have rights, even if they're not paying you the rent. You have to go through the court system. Only the court, unfortunately, can order them out. And sometimes that could be a problem depending on where you're at and what the situation is, what the laws are where you are. I got an interesting one here for the tenants. Let me see. Mortgages, renters, that's good housing. Reverse mortgages. Okay, let me go through my things here, my videos, get some interesting ones. Tenants. Where's the renter one? All right, let me take a look. Give me 1 second here. I'm going to show you a video once I find it. There's a situation of a tenant who just would not leave. And I found a couple of good examples of this. Okay, not there. Just gotta find them. Oh, here we go. Squat. Wait, no, that's not it. Squatters. The squatters claiming ownership. I got a lot of videos here. Videos under promotion. It may be that I just did not put out the video and I just got the link to it. I think that may be the case. It's maybe a situation where I did not download it. So let me pull up. Yeah, I think that's a situation I didn't download it. All right, so let's go to the web browser. Where's my web browser? Is it open still? There we go. Go down to rental topics. And yeah, I don't know if this is the video that I had that I wanted to show. Let me see.
Son, we're grabbing burgers for dinner if you're interested. I'm
Skip that ad.
I like to call them serial squatters, and that's what they do.
There's a North Texas couple out there tonight playing a very aggravating game of cat and mouse with other people's homes. They move in and then refuse to move out, owing homeowners tens of thousands of dollars.
Our consumer justice investigator, Kristen Severance, joining us right now. You have spent months working on this story.
Yeah, I'm going to introduce you to Heather and William Schwab. Court records show that they've been getting evicted since 2005. They were kicked out of vacant homes just in the last 2 years. And we found they keep moving into nicer and more expensive places. I spent 2 hours with them.
Christine Reddick was trying to find the perfect family to rent her late father's home. She thought Heather and William Eric Schwab were it.
And that's how important this was. We did one of these for hours. It's like, here's your keys, come on in.
She says everything on their application checked out, from salary to rental history.
How much was rent a month? It was over 2.
Right away, the rent check bounced and the excuses started.
Can't talk. Eric's grandmother died. CPS is coming over. I got fired at my job. You can only go so far with a story. I was born at night, not last night.
Christine started the eviction process.
There's a process, and the weird thing is it protects them or buys them more time.
The Schwabs moved in July and were kicked out 5 months later.
There was stuff everywhere. They smoked in the house. My pool was now a Mountain Dew green.
They still owe her more than $7,000. Christine, a realtor, said they lied on their application.
Nobody in their right mind would lease to somebody with all those evictions.
She had no idea the Schwabs had been doing this for years. Court records show they were evicted at least 14 times before moving into Christine's home. Former landlords say they use fake information to get in and work the system to stay as long as possible without paying. And they bring several kids and pets along with them.
What I don't understand is how.
Records show the Schwabs were evicted 2 more times before moving into Dustin and Arlene Harrison's home in Carrollton.
They made it a big deal, like, hey, it's Thanksgiving, we just need to get in real quick, and just seem like good guys, good people, to be honest.
The Schwabs claim they were military veterans, just like the Harrisons, and small business owners.
And they own their own collection agency.
The first check was no good.
It bounced, but they're already in, but that's a part of their thing.
Dustin said he kept covering rent, giving them more time.
I'm just a good old East Texas boy, just I'll help you out.
Then the Harrisons started getting foreclosure notices.
We were paying a mortgage on a home that they were just squatting in.
The Harrisons tried to evict the Schwabs themselves, but quickly learned
These people know more than we do. So I contacted a lawyer.
I like to call them serial squatters. And that's what they do.
the Harrisons hired attorney Mark Gerling. Gerling knew the Schwabs. He had just evicted them from a home in Louisville.
They know eviction law in some cases, as well as many attorneys.
The Schwabs were kicked out of the Harrisons' home 7 months after moving in.
The animals peed everywhere. Really gross.
It was horrible.
And thanks to the Schwabs, their credit was now horrible too.
I don't know if we should tell you credit scores, but we're a 780. I'm a 530.
The Schwabs left
Oh my
their
God.
home and moved into a house a mile away. They were evicted. They moved 0.9 miles from that home and were evicted again.
These people are chronically just victimizing and no one's holding them accountable.
We found the Schwabs had moved into a gated community in Frisco. They were living in this $450,000 home, got evicted, and moved 0.3 miles away to another home in the same development. We tracked down Heather outside of court on a bad check charge. We'd like to talk to you about all your evictions. We found at least 20 over the last 17 years. First, she claimed ignorance.
What are you talking about?
Well, you and your husband, you don't pay rent and you keep going into more expensive
Okay,
homes when
I
you owe
have
thousands of dollars in back
No
rent.
idea what you're talking about.
Then she said it was another Heather Schwab.
Well, I know there's another Heather Schwab, in fact, in the same court I am.
So
So
it's definitely you. We've been investigating this for months.
for months, I
17 years.
cannot help you.
But you're the one who did it.
Ma'am, I don't even know what you're talking about.
Here, let's go over all of these landlords.
Well,
Christine Reddick,
I've got an
Matthew Laubert.
appointment. I've got an appointment.
Do
I
you plan
don't
on
know what
paying
you're
any of this
talking
rent?
about. I don't know what you're talking about, Heather. Now, excuse me.
About a month after Heather and I talked, the Schwabs were getting evicted again.
I'm just still in shock.
Chrissy Merrill said Heather and William owe them at least $4,000.
I think it's criminal to move into a house knowing you have no intentions of paying rent.
Their attorney is Jeff Sprigg.
The Schwabs like to game the system.
Sprigg, too, had just evicted the Schwabs.
They know what to look for. They know who their victims are going to be.
In court fighting the eviction, William Schwab said they were too poor to pay, and they only made $3,500 a month. Sprigg showed the judge their W-2, which shows they made more than $15,000 a month. Days after that court appearance, they were evicted in the beginning of October.
The whole house is missing smoke detectors, trash. I mean, I think this is dog poop.
They moved from the Merrills to a $473,000 four-bedroom located just 10 homes away.
If you could say something to the Schwabs, what would you say?
How do you sleep at night?
So the homeowner in their new place is currently trying to evict them. That homeowner hired attorney Jeff
I know how they sleep at night. Rent free.
Craig, who told us that the
Holy
Schwabs will
crap.
sometimes target homes that are for sale. They say they're going to buy the place and pay rent until closing. That way they don't have to go through any background check or fill out a rental application.
Heck,
Do not ever give somebody the keys to a rental without the background checks and the city inspections and all that.
what every one of you are probably feeling right now, and that is we have zero vested interest in these properties, and blood is boiling. How do
Yes.
they get away with this?
Everybody wants to know, right? How do they keep doing this? Well, everyone that we talked to told us
We're no longer able to see the video.
we talked to a lawmaker trying to change that. We'll explain how he wants to stop these serial squatters. We'll have that part of that story tomorrow.
You'd think there'd be something to stop them, but apparently
Right.
at the moment there's not.
Right. And they don't care about civil. They don't care about judgments or
Cannot
civil
wait for
action.
tomorrow night.
Oh my
Follow us.
gosh,
Thank you.
yes.
You bet.
Wow, we are glued. Okay, so if you need consumer justice, you know.
Anyway, I don't have any additional information on it other than that. So that's that. But you got bad tenants out there. Sometimes they don't pay the rent. They know the law is better than the landlords. They game the system like that. This is in Texas, but it's all over the place. I mean, I got tons of renters videos with even eviction specialists and such, nightmare tenants. I mean, I got goof videos too, but I mean, that's not the video I was looking to show you guys, but it's a lesson in itself. So it's it's all good. Let me take a look and see rental topics, eviction. Yeah, it's the serial squatters, and then that's something else. All right, I don't want to get into that. So let's go back to the slideshow. All right, so the tenants do have rights. You cannot just rip them out by their hair and throw them out on the street. The tenants need to be evicted. And eviction is the legal process of revoking those rights that they have to occupy. And if they know their rights and they got children there and they say, well, where are we going to go? You're going to kick us out on the street, especially if it's winter time. Forget it. People can game the system for a while. And look at this. They start ruining the homeowner's credit. The homeowner starts getting foreclosed on when they previously didn't have any issues, because the tenant put them in that situation. So, sometimes if it's a listed property, you got to be careful. There's scams going on out there too, where you get these scam artists that they look for listings. You advertise the property, they'll copy your ad and put it on like Craigslist or something. They'll go to the house. If you listed that it was vacant, do not write that anywhere publicly. If you put it in the MLS, you'd put that in the licensee's notes, but don't ever put vacant, that the home is vacant in an ad, because you'll get people that'll go over there. They will break in, change the locks, advertise the property as available. They'll meet people at the house to show them that house. They'll sign a lease with them, give them the keys, and they'll say, well, we need either cash or for whatever reason, or we're moving, we already closed the bank account, we need to, or I don't know, whatever the hell their reason is. They'll tell you to bring them cash or a money order, and they'll go and they'll cash that out, and then they'll disappear. You'll never see them again. You'll never see them again because they're not the real owner of the property. They went in and they used your listing. They sign a lease with somebody. That person's now moving in. They gave them the keys to the home, and they didn't even realize that they're not even the real owner. There's all kinds of scams and crap that go on like that. Scary world out there. So here's some of the standard provisions of a lease that should be added into any lease. Okay. The parties have to have capacity to the contract. They're competent parties, just like any other contract. There's a demising clause that says the landlord is to let and the lessee, the tenant, is to take possession of the premises. There has to be a description of the premises, what exactly is being rented and what the tenant cannot use. So maybe the tenant can't have use of the garage. You're renting them the house, but the garage, that's where you got your stuff in, or maybe you're renting it out to someone else, or maybe they can only use half the basement. You need to specify what they can and cannot use. The terms must be clearly stated. The duration, what's the start date, what's the end date? You don't just say 1 year. You have to have the dates there. Specifics of rent and how and when it's to be paid, because if you don't put that in the lease, when does the New Jersey law say the rent is due? In the arrears, at the end of the month, after they lived there for the entire month. So you need to be specific and put that the rent is due on the first of the month. Otherwise, it's actually due on the last day, according to the law. Leases must be in writing if for a term of more than 3 years. They can be recorded if they're more than 2. In any case, if a real estate agent's involved, it always needs to be in writing. And then signatures. Everybody needs to sign a lease. You know, everybody needs to sign the contract. You can't have only the tenant signing the contract. Landlord needs to sign it too. Otherwise, you don't have a valid contract there. Contract, in order for it to be enforceable, needs to be signed by everybody. All right. Did we highlight anything under tenancy at sufferance? I don't think we did we? On page 197?
No.
All right, so highlight the first 3 lines up to the end of that sentence, the first sentence. And after you highlight those first 3 lines, above it, I want you to write, they're also not paying rent. Also not paying rent. Because it says tenancy at sufferance arises when a tenant lawfully came into possession of real property and continues after the rights had expired to hold possession of the premises without the consent of the landlord. A tenant at sufferance can be evicted at any time. Right there, that they're also not paying rent. They didn't just hold over, but they're not paying rent. If they held over and they're paying rent, it wouldn't be a problem. But they're not. And then we went over standard provisions of a lease. Then we, yes.
Just a quick question. So if the lease was done, but they continued to pay, let's say they just in their mind wanted to pay for a few months and then they were going to move out, that is called a
well, they're still a holdover tenant, but they're just month to month now if the landlord allows it, but the landlord doesn't have to.
Okay.
Now, if their lease expired, they had a 1-year lease and the landlord wants them to sign another year lease, but they didn't sign it. Instead, they just paid the landlord the rent. The landlord should not accept the rent until they have a lease signed. Because if you just accept the rent, the actions of the landlord accepting the rental payment creates an implied contract that they're okay with you remaining there as a month-to-month tenant now. Now, in order to get out a month-to-month tenant, how much notice is needed to terminate their lease?
1 month.
1 month. 1 month's notice from when? From the time before the rent is due. So if they just paid this month's rent, you have to wait until just before next month's rent and then give them a month, or you could give them the notice now, but it doesn't matter. It's still going to be 1 month from before the rent is due next month. This is why it could take a while to get people out. Now, every lease has here's the recap. Here's a nice slide with everything there. Every lease has the demising clause. A transfer of property by lease is known as demise. You don't confuse that with devise, which was a transfer of property by will upon death. Demise is a transfer of property by lease. A leasehold estate is just defines the tenant's rights to occupy someone else's property for a period of time. So a lease is considered personal intangible asset. Personal property and an intangible asset. A holdover tenant is a tenant who has held over after their lease rights had expired and they did not vacate at the end of the term. Now, once again, the landlord could either accept that holdover tenant if they're paying the rent, or well, whether they're paying the rent or not, the landlord could accept it or say, no, I'm not going to allow you to be here without a written lease. So whether they wanted to pay the rent or not, the landlord does not need to accept it. If they're not paying the rent, well, the landlord can move to evict them immediately. No notice is needed. Non-payment of rent, no notice is needed. That's the only thing that no advance notice is needed to give to the tenant before you go down to the courthouse to file the eviction process to start it up. So once again, 4 types of leasehold estates. Estate for years. What's its distinguishing characteristic? It's for a fixed period of time, has an end date in it. Periodic estates. No notice is needed at the end of that lease term to in order to start eviction on that tenant if they did not move out. Periodic estates. It's also known as an estate from period to period. It automatically renews for the same amount of time that the original lease was written for. In order to terminate a periodic estate, well, that time varies depending on the length of the estate. So before the renewal, the tenant should give, if it's for a period of years, how much notice is needed to terminate it.
3 months?
3 months. If it's week to week, 1 week, month to month, 1 month, right? Tenancy at will. They could stay there at the landlord's will. It's for an indefinite period of time. Requires how much time to terminate? 3 months. And a tenancy at sufferance is a tenant who doesn't even belong there. Their lease expired. They didn't move out. They didn't sign a new lease. They're not paying rent. So a tenant at sufferance can be evicted at any time.